But direction of the wind can change also.
That's what I'm saying. Lest I change the direction of the wind. If your lordship is pleased that public interest would benefit by equietous of signing the settlement at 470 billion in a full and final settlement, can come back and say, if you knew it's very easy to say, go try the soup for those who have no stake. Those who know the realities of the uncertainty of litigation will never make that clear. Look at page 1433. The whole discussion goes on. And at para 134, this point is put to rest. But the petitioner says that in the process of evolving what is fair, reasonable, adequate, some of the elements of essential relevant to fairness and adequacy, such as provision for future medical surveillance and the likely future but unforeseen manifestation of toxic injury, having regard to the nature of the hazard, have not been kept in mind, and therefore please mark these words. The approval accorded to the settlement is on an incomplete criteria. But the UCC would say that the Union of India was aware of the possibility of such future manifestations of the effect and must be deemed to have kept those in mind at the time of settlement. But the point to emphasize is those who are not parties to the process of settlement are assailing the settlement on these grounds. In personal injury actions, the possibility of further aggravation of the condition and consequent aggravation are taken into account in the assessment of damages. The estimate of damages is a very delicate exercise requiring evaluation of many criteria, some of which may border on imponderable. And then the whole discussion goes on this. And it ends by saying, even if the award is a once for all determination, these aspects will be taken into account. And then, after discussing the fairness hearing principle, page 97. In our opinion, I'm showing this because one of the American jurisprudence have been.
What is the paragraph number?
I'm so sorry, 140. The American principles, your lordships have said, will not apply. Para 140. In our opinion, the right of victims relating to Section 4 of the Act to express their views on proposed settlement does not contribute to a position analogous to that in the United States, in which fairness hearings are imperative, either on their global settlement. Section 4 of the Act, to which right is traceable, merely enjoins the Government of India to have due regard to the views expressed. The power of union under the Act to enter into a compromise is not necessarily confined to a situation where the suit came to be instituted on behalf of the victims. Statute enables Union of India to enter into a compromise even without a suit. The right of being heard and read into form and subject to its constitutionality has been upheld in Sahu, subjects the Union to a corresponding obligation. But the obligation doesn't envisage a procedure like the fairness hearing as in the condition precedent to a compromise that the Union of India may reach in a situation in which it may do not necessarily to a suit. Accordingly, contention G is answered. The whole settlement is not vitiated for the reason alone for want of a fairness hearing. Likewise, the settlement is not vitiated by reason of the absence of a reopener clause built into it. Now, one of your lordships have not been shown any statute which was overlooked by coming to this conclusion, or some binding judgment of this court to the contrary, which was missed. In saying in a curative, this is a big egregious error. Is correct.
No, whether contention of the Union of India that award this consent order should be set aside, settlement should be set aside. Is it recorded anywhere at the time of hearing in this judgment?
Yes, the Union of India challenged this.
No, whether Union of India argued before the review court that the settlement should be set aside.
Yes, they did. In fact, they went to the extent of saying this is for stifling prosecution opposed to public policy. Set aside the whole settlement. In fact, para 142, it immediately answers what Madam Justice Loka is putting today on. Para 143, please see.
Yes.
The stand of the Union of India and other petitioners is that even upon setting aside of the settlement, fund should not be allowed to be repaid.
Right.
So they clearly challenge. Now the question was, what happens to the money? Your lordships in 142.
Well,
05, you read out.
Para 12.
Yes.
In here, Chief Justice Mishra's
Yes.
judgment.
And Union of India, paragraph 9, sorry.
Nine.
Nine.
Correct. Supported the stand.
Correct. Who have asked for a review. And in fact, one of the subject there to Mr. Gupta, he wanted me to read a paragraph. There, the union was criticized. The union was criticized for running the stifling of prosecution point. Where your lordship said, behold, that the doctrine of stifling prosecution is not attracted in reaching the conclusion. You don't put out a consultation that Union of India would, under threat of prosecution, coerce UCC to pay 470 and apart. In the context of the Union of India, the plea lacks as much reality as any sense of proportion. In fact, the argument was interesting. It is bad because under threat of prosecution, UCC agreed to pay. Lordship said this argument is not only bad, it lacks sense of proportion because. But please see page 98, para H.
Para H.
Yes. This also, my lord, answers your lordship's point.
Right.
If your lordship sees para 3,
Right.
Keep the money back till such time as the decree is passed in the suit. What they were saying is, restitution, yes, we will keep it in trust to appropriate against any decree which may be made.
Suit should go back then.
Suit had to be tried. Page 661, para 146.
146.
Then one of the arguments was, may I read from 145. The learned Attorney General also sought to point out that UCC had subsequent to the settlement effected certain corporate and administrative changes, and without a full disclosure by the UCC of these changes and their effect on the interests of the claimants, the fund should not be permitted to be taken out of the court jurisdiction. However, Government of India also should not be free to appropriate or use the funds. We are not impressed by any of these contentions. It is not shown that the UCC brought in monies with any undue haste with a view to confronting Union of India with the fate accomplished. The records indicate a different complexion of the matter. The payment appears to have been expedited at the instance of the Union of India itself. Strictly speaking, no restitution in the sense of any funds obtained and appropriated by the Union required to be paid by the back arises. The funds brought in by UCC are deposited in the RBI.
Ultimately, court says that restitution will follow, but that safeguard should be maintained.
Correct. Well, that will be, but they said in any case,
Right.
it will be done.
Court says.
Because one very important thing your lordship say in 148, and this is the strength of our system. However serious the incident may have been, the rule of law, my lord, has to stand.
Yeah.
And in the middle of para 148, your lordship says it is the duty of the court to ensure no litigant goes back with the feeling that he was prejudiced by an act which he did on the faith of the court. That's a very important consideration. Then para 153, your lordship says, we are satisfied.
Just one minute, just one second.
Now it's more. And what has become more is 50,000 has become 500,000 of minor injury. And that's the long and short of the curative.
Yeah.
Manan, I submit that fact, there's no top-up issue. That's, I don't think I can assist your lordship anymore on this. There are a lot series of, I'm only staying it in 2 minutes. Series of affidavits filed. Series of affidavits starting with 1994, 1995, and ending as late as 2011, where the Union of India has opposed every single attempt to suggest that the settlement is inane. Affidavit upon affidavit upon affidavit. Argument before your lordship says the settlement has become adequate because the rupee depreciated. Go back to 89 and compare. But that can't be a ground for top-up. In the long and short of my submission.
So Salve, which are the pages of the affidavits where prior to curative?
Yes.
They keep saying that.
That's very important. May I very quickly show 4 or 5 pages and then I'm done.
Just give me the page numbers. That's all.
First is volume 9, 12 December 95.
That is your volume 9.
Yes, ma'am.
12th December.
95. There's a,
What page is this?
yes, it starts at page 2149.
Okay,
Please just,
that's fine. Next.
yes, please just mark para 5 and 6.
Yeah.
Then, my lord, 2003, there is a 32 petition file in which your lordship direct disbursal, where this 1300 crore figure came in, the 1500 figure came in. That's only, my lord, for the record. Your lordship's order is at page 2067 of volume 8.
Mr. Salve,
Yes.
can you do me this favor ask the instructing counsel on
On a piece of paper.
Just give the.
There is a written submission which I am filing and which I am inviting your lordship not to waste your time reading, except maybe
Does it
to
have
assist you on these
No.
pages.
Does it have the paragraph number?
Yeah, it
That's all.
does. Beyond that, my lord, please don't waste your time reading it. I mean, it says nothing more. It says in 20 pages what I've said. 10 minutes to your lordship. And I don't think the matter requires.
I just need those instead of noting down, so that there's no easier to locate those. That's all.
Are you doing it? TDCC, we don't know. Copies, please hand over. Your lordship had asked us to file written notes. This is that written note. What your lordship is looking for. Yes, it's in Roman 5, page 7 onwards. Extracts are given in page number. Put all of it. Yeah,
Thank you.
not unless there's anything else I can say.
Thank you.
Since your lordships have not discharged the alternative board, I take leave.
Thank you.
And we ask you to approach report one.
Anything you want to say, Penny?
Not just to. Sorry.
Yes. Anything else, Attorney? I think both of you already debated it. What can be an rejoinder in this?
I think we will even do it even earlier if possible.
No, you want to say something? I thought there's nothing to
I-
say one
I
way or
will-
the other. We have
a
understood
couple
the
of
point.
things
The
just to say.
point is in a limited compass. Yes.
It won't be any manner of repetition. Right?
Okay.
To tie up certain threads.
May I be excused?
Either threads are open or closed. If they are still open, how will you tie them?
No. We have traveled quite a distance in understanding a lot of things had to be unraveled to comprehend. There are so many things that have happened over a period of time. And I looked at, again, there are three claims in the curative petition. One on the compensation amount to be upgraded. The other in relation to the environment mitigation, and the third in relation to the expenditures and rehabilitation and all that. So when the curative petition was filed, the Madhya Pradesh High Court was still in season of a writ petition filed challenging the issue of environmental mitigation. And the respondent then entered appearance, some objections were taken, and I'm told they had placed before the High Court certain documents in confidence, which I had no idea at all. And after the review, the curative petition was filed, the Union of India had filed a transfer petition, which is also tagged along with the curative petition and is heard along with that. But since the High Court is in season of the matter, the question whether they would be subject to a liability on that question or not is still a matter at large. And I don't think in these proceedings I could probably ask your lordships to go into that question because a number of other issues that arise, I don't think
That may not be appropriate.
fairly stated and on a high level of integrity of the procedure. We are confined to the question of the liabilities as far as the quantum of compensation for the victims are concerned.
This transfer
So,
petition, the TP is also listed before us.
Yes,
It is listed.
There's a transfer petition which is
501.1.
That is filed by you.
Union of India had filed a transfer petition, and the transfer even was not even ordered. Unfortunately, it was lying pending with the
So
court.
simplest thing is to pass a
So,
dismissal
what
order
it
and
says is the High Court is in season of the matter, and the
Correct.
High Court will
Transfer
continue to
petition.
hear the proceedings.
dismiss the transfer petition. That's all. Don't say anything more.
And say the High Court will give the petition number.
No, once we dismiss the transfer petition, that means we are not transferring it before us. That's all.
And I know, but anything Lord's mistake regards the continued liability of the UCC and this may or may not come in the way the High Court will.
We've not.
On the question of any liability on any other account, because I know there are some passages in the judgment which
We are not touching that.
obliquely looks at it, but I don't think
We are not
directly has a
touching that.
bearing on it. And the other issue also I think should be connected. I don't think I can also go in the question of the rehabilitation exercise compensation paid on that.
Cannot.
Because that's a matter on there could be more than one point of view, some factual, today we not even spend that money. How much more we'll spend all that? I don't think. So though they are part of the claims for some very policy reasons, they've been brought as part of the curative petition, but maybe for good reasons, I would confine myself a little bit. Now, I look at the turn of events over a
So
period of
claim
time.
3 you are not pressing.
Yeah, they can be pursued in accordance with law in appropriate procedure.
Appropriate procedure. Claim 3 goes there.
That's right. The review judgment broadly looked at 2 or 3 troubling issues. While it is true that Union of India did not itself file a review petition, but supported the review proceedings, and in the penalty paid paragraph of the affidavit, it says that the settlement may be deserved to be reopened. So the extent of reopening, the nature of the degree of opening, whether it is to completely undo the settlement or to have a review limited to the extent of looking at the quantum of compensation, where probably that was the main focus, it seems to be, as I read the affidavit in total.
See, in the
Not that-
background, in the background of the order in the review petition, you are wiser in the curative petition to the extent you would like to claim.
Maybe wiser,
All I
little
say.
more wiser.
So
No, I look at
therefore you were fair to say that look, in view of the proceedings gone by, it's not even advisable to pray for reopening the settlement. What you are therefore, any time I said you want the settlement to be talked of.
exactly.
Yes, it has happened. There are certain other
Exactly.
supervening
Exactly.
circumstances and facts which would require the court, according to you, to exercise whatever inherent power, whatever power you feel, look at a larger conspectus of the situation.
Great.
And in that process, you feel something more should be added.
That's-
Given the figures and facts and figures which you
That's. Well, I look at the affidavit only from that perspective, and I think that must have been the whole idea behind it. I don't think Union of India, having gone into the settlement and supported it, said right for the immediacy and all that, but I said undo the settlement fundamentally. I don't think that was probably the intention. So the review judgment had looked at some of the basic concerns urgent for the claimants and the writ petitioner. One is that having been kept away in the entire process of adjudication and Government of India had taken over the right to represent us. So there are several casualties, the fairness hearing and the participation in the settlement procedure and so on and so forth. And the quantum of settlement, the figures, how do you arrive at these figures? There could be no finality at this point of time. All those very important concerns were raised before the court. And they're all summed up in paragraph 55 in several contentions. Paragraph 55 of the review judgment. And there is observations made in the context of one, probably has been read in the context of some other contention. Therefore, I thought it important for a purpose that the contention raised in respect of each one of those must be kept within the scope of those contentions. And sometimes you read one in the context of one, that could be a small.
A to H. A to H.
That's right. Now, therefore, the paragraph 55, contention F is about, this is paragraph 55 of the review judgment. So I read from volume 1 of the respondent's compilation. The other contention relating to criminal prosecution, court settlement, I'm not looking at all of them. Contention F is the memorandum of settlement. The order that the court thereon properly construed make inference inescapable to the part of the consideration whether stifling of the criminal prosecution is opposed to public policy. This vitiates the agreement on the settlement is based on unlawfulness. That one contention relating to criminal prosecution. Then turn over to contention H.
That is regarding restitution.
Contention H, yes.
Restitution.
Even if the settlement is reviewed and set aside, there is no compulsion or obligation to refund and restore to the UCC the funds brought by it as such. Restitution is discretionary. Excise and discretion, the interest of the victims is kept in mind and restitution denied. But all, even if restitution is to be allowed, the UCC would not be required to act upon and effectuate its undertaking dated so and so on the basis of it order dated so and so, vacating the injunction against was made. Then contention J. That the settlement required to be set aside in the original suit directed to be proceeded with on the merits. If so, and what other reliefs required to be granted, what are the directions required to be issued. So when you read contention J, let me read the first contention H at page paragraph 142. § 188. the same time, it's necessary to remind ourselves that in bestowing a second thought whether a settlement is just, fair, and adequate, we should not proceed on the premise so has been finally established, yet to be decided in the matter goes to trial. For all those things went into the decision-making process of the court, looking at whether I should undo the settlement at all. So when the court has ultimately thought we're not going to undo the settlement, but we'll still, that's why when it gave a final thought on the question in paragraph 205 about what happened to the future symptomatic now, asymptomatic now, symptomatic later. So that's where those people may come for a claim later, we should take care of them. It ends at that. It ends at that. I would probably look at us, your lordships, to read this review judgment and the first order of May 4, 1989 together. Please read them together. Even if there was no reopener clause in the settlement, but the court in the 4th May 1989 order, the final paragraph, for all practical purposes, is the reopener clause. It is a reopener clause that the court has introduced into the settlement because the wide range of complexities which a matter of this nature was brought to the fore of the court. If I am not too off the mark in requesting the court to read it as the reopener clause, kindly come back to that. It's been read again and again, but so paragraph 38 of the settlement justification. So having said this, I thought, the way one can read it fairly, the review judgment thought there is already a certain guarantee and that can probably take care of. That's why although the arguments about settlement did not have all these concerns, those fairness opportunities are not there. So that, I think, in all fairness, to whatever extent justice may be done, paragraph 38 may be read as the reopener clause, and we read these judgments, we read as one continuum of a judicial process. They may have happened at different points of time, but one.
No, but in fact, settlement was specifically challenged on the ground that there was no reopener clause, and that
in the settlement.
Correct. And that contention has been specifically
That's
rejected.
right. That's right. In the settlement, there was no reopener. But while the court endorsing the settlement had this in mind. So what was lost in the settlement was compensated and adequately taken care of with this paragraph. In all humility, and I don't think I'm doing injustice to reading judgments this way. If the judgment meant something, that's why I said this probably would not go in vain. So if that would not be too wrong to read it as part of to judgment to be read as a continuum, and this as a reopener clause, to whatever extent Union of India got to your lordship's notice, the unfolding events over a period of time, and I also read out that the ex gratia payment will be excluded under the scheme of the Act and all that. That's why I thought it is in a matter like this, while the undoing of a settlement has been put to rest by a curative petition and having regard to the intent of the Union of India in the affidavit filed in the review proceedings, the curative petition must be taken to a certain level where if the ends of justice of those who are waiting for justice for long can somehow be secured. And that's where probably the curative petition will be looked at. And I've seen all those proceedings in US. I placed on record about the complete lot of settlements. And those, I just give an index of those documents, where the US procedures on fairness hearing, and there are doubts raised whether for future claims, how do you look at them? So a bankruptcy process is also sought to be introduced in all those settlement issues. So it has flown in different directions. But ultimately, it's kept open. All these long proceedings in US, as business particularly, it kept open the possibility for people to secure probably the ends of justice at some point of time. So you put it at a higher level of principles of natural justice. And like all that you say is, I'm sure I must have my day in the court. Your lordships, that's how it's put. So ultimate questions come to the mind of a claimant is, did I have a day in the court at all? I have so many years of waiting. So yesterday I did not point to a lot to say about those fraud and mistake. Just a couple of paragraphs of
The paragraphs of what written?
No, I'm not looking at those documents about suppression of facts as a fraud from the point
I
of
don't know
view.
what are you proposing to read?
Your Lordship, please.
What are you proposing to read? I want.
No, I'm just giving. We have placed on compilation of articles and extracts from books.
Yes.
It is that yesterday, while Your Lordship is rising, the concept of a fraud mistake is so wide. It's so wide. That's all I wanted to point out. If it is so wide,
Not the time period, then say arguments concluded or the result.
Point will not I want to.
No second, third, fourth.
It's only what I'm trying to say is only will not. It's a very
Please understand. Some discipline of the court proceeding must be maintained. We have heard both of you against reasonable time. Now, in a rejoinder, we will not.
Not rejoinder, but I'm just trying to inform them. No, not rejoinder. What I'm trying to say is, there is a figure which has been given. Now, in addition to that, once the medical documents are made available, it will increase. Plus, not the future. So therefore, that will be an anomaly of the problem. That's all I wanted.
Thank you.
I'm grateful to that.
Deeply obliged.
Thank you.
Deeply.